Hi everyone, welcome back to our channel. I hope you all are doing good. So let us start with the revision of our next chapter, chapter 16 of the Companies Act 2013, which is prevention of oppression and mismanagement. This chapter is very important from your examination point of view, and you can expect a short 4-mark descriptive question out of this chapter, and a 2 marks MCQ could also be asked. So this is a very small chapter. It consists of only 5 sections, and getting 6 marks from 5 section is very good. So before moving on to the provisions, this you need to understand the meaning of certain terms and the central theme behind this chapter, that why this chapter came into picture. This chapter, covers the oppression against the members of the company only. Any oppression against the directors, the creditors, third party is not covered under this chapter. So the very first, term of which meaning we need to understand is oppression. What do you mean by oppression? Oppression means taking away the legal right. As we are discussing about the member only, so taking away the legal right of a member is oppression. Okay, how can we understand that? For example, the company has not declared the dividend for the year. Is this an oppression? No, because declaration of dividend is not mandatory for a company. The declaration of dividend depends on the discretion of the board of directors. But if the company has declared a dividend and has paid the dividend to all the shareholders except one, this is oppression against that shareholder who has not got dividend from the company. Okay. The next term we have is mismanagement. Mismanagement, as the name itself suggests, is that the affairs of the company is not being conducted in a wise manner. What do you mean by a wise manner? A wise manner means that the affairs are being conducted in a manner which is prejudicial to the public interest, the interest of company, or the interest of members, or where there is any material change has taken place in the management or control of the company, which is likely that the affairs will be conducted in a manner prejudicial to public interest of company, and interest of members. Okay, so what is the central theme behind this chapter? Remember the one shareholder who has not got dividend by the company. This chapter provides right to that shareholder to apply to the tribunal seeking relief from such oppression. Okay, the tribunal, after verifying that if actually any oppression has taken place against the member, tribunal has certain powers to exercise against the company. It can give a few directions to the company. So this chapter is all about that. Moving to the first section, Section 241, application to tribunal for relief in case of oppression, etc. So, when an application could be made to the tribunal, NCLT, that is, when the affairs of the company have been conducted or are being conducted in a manner which is prejudicial to the public interest of company, and interest of members, any of the three, or when there is any material change that has taken place in the control or management of the company, and it is likely that the affairs will be conducted in a manner which is prejudicial to the public interest of company, or interest of members, it can make an application to the tribunal seeking relief. So basically, when there is any mismanagement that has taken place in the company, so we can make an application. Who can make an application? The application could be made either by persons eligible under section 244 or by the central government. Now the central government, this point has a change, has an amendment in it, so this makes it more important for your examination. Moving ahead, what are the circumstances when an application could be made by the central government to the tribunal for seeking relief? So we have 4 such circumstances. If any person concerned in the conduct or management of affairs of the company is found guilty of fraud, misfeasance, negligence, default in complying any of his duties or obligations, or breach of trust. Though, so in these following circumstances, the central government can make an application on when any person concerned in the conduct or management of the company is likely to cause serious damage or injury to the interest of trade or industry to which such company pertains, or when the business of the company has not been conducted in accordance with sound business practices or prudent commercial practices, or when the business of the company has been conducted or managed with an intention to defraud its creditors or members, etc., or for any unlawful or fraudulent purpose. So these are the circumstances. What are they? When the person concerned is guilty of fraud, misfeasance, negligence, or has caused or likely to cause serious damage to the trade or industry in which the company pertains, or when the business of the company has not been conducted in accordance with the sound business practices, or with the intention to defraud the creditors or fraudulent purpose. So, what are the powers the tribunal has when the tribunal got to know that there is something wrong going on the company? So, section 242, we have our next section. Powers of tribunal. When the tribunal is of opinion that the affairs of the company are being conducted in a prejudicial manner, and winding up of the company would unfairly be prejudicial to such members, then the tribunal may pass any of the orders. So these are the list of orders, these are the illustrative orders that the tribunal can pass. Tribunal can make any order as it may deem fit. Let's see what all orders it can pass. First, the regulation of conduct of affairs, purchase of shares by another member or the company, then reduction of share capital, then restriction on transfer or allotment of securities, then tribunal can terminate, set aside, modify the agreement between the company, manager, MD or other director, and any agreement between the company or any third person. Then tribunal can recover, pass an order for recovery of any undue gains made by the manager, MD or the director. Then it can pass an order for removal of MD, manager, director, for imposition of cost, or for setting aside any of the transfer or delivery of any property done by the company in last 3 months. Then it can make an appointment of directors who will report to the tribunal, and tribunal can pass any other order as it may deem fit. The order of tribunal has to be filed with the ROC within a period of 30 days from the date of passing of order, and tribunal may pass even an interim order if an application of for such is made by any of the parties. This is again an amendment which is very important. When the application is made by the central government to the tribunal on the conclusion of a hearing shall record its decision as to whether the respondent is a fit or proper person to hold the office of a director if or not, and if not, the director or the respondent shall have to vacate his office. If any alteration is made to the MOA and AOA by the tribunal or by the company, so it shall file the revised MOA and AOA to the ROC within a period of 30 days. When can an alteration to MOA or AOA is possible? When the tribunal has passed any order for reduction of share capital, for restriction on transfer or allotment of shares, or for purchase of shares by any other member or company. Okay. If the company or officers have defaulted or contravened any of the provisions, this punishment shall be levied. The company shall be fined for a amount up to rupees 1 lakh, which may extend to 5 lakh, and every officer who is in default shall be levied with the fine of 25,000, which may extend to 1 lakh, and an imprisonment up to 6 months could also be made to the officer in default. Section 243. Consequences of termination, modification or setting aside. Whenever the company terminates or modifies any agreement, the company shall not provide for any compensation for loss of office that has occurred due to cancellation of contract, and the managing director, manager or director cannot be appointed for a period of 5 years, okay, in that company. without prior approval of tribunal. It again has an amendment that whenever the tribunal has concluded that the respondent is not a fit and proper person, such a person shall not hold office in any company for a period of 5 years from the date of decision, except with the approval of tribunal. And if the company if the person has contravened any of the provisions of section 243, a fine up to rupees 5 lakh could be levied along with the imprisonment up to 6 months. Okay, so this section particularly speaks that whenever there is any termination of office of any person due to order of tribunal, the company is not required to pay any compensation. The company can pay only the claim which is due to that person, but no compensation in addition of any claim will be paid by the company. Coming to the next section, section 244. Remember, under section 241, two persons can make an application to the tribunal seeking relief. The one is the central government and second was the person eligible under section 244. So who all are the persons who are eligible under section 244? Now we are going to look into that. Section 244, right to apply under section 241. Who are eligible for application made to the tribunal for the company having a share capital or for the company not having a share capital. For those company who are having a share capital, 100 members or 1/10 of the total number of members or members holding 1/10 of the issued share capital, whichever is lower. And for the company which do not have a share capital with them, at least 1/5 of the total number of members. Okay. Moving on, there are certain important points that you need to remember because ICAI has already asked so many questions based on these points. So let us start with the first point. The applicant must have paid all the shares and other sums due before making an application under section 241. Then the joint holders are to be treated as one, and any person entitled to share but his name is not entered in the register of members cannot apply. Okay. Then withdrawal of this is what the potential equity shareholders means. Okay, then withdrawal of application after it is admitted by the tribunal shall not invalidate any further proceedings. That is, the consent has to be checked at the time of making the application. The legal representative of deceased member can also apply, and the minority shareholders can also apply. I have highlighted the relevant case laws alongside the important point. Okay, then failure to declare dividend does not amount to operation, as the declaration of dividend is not mandatory. It is the discretion of the board of directors. Then continuous losses in the company is not operation because and earning a profit or a loss is based on the functioning of a company may incur profit and in 1 year and may face certain losses in the subsequent year also. Then member must be aggrieved in his own capacity. For example, if a person is a member in a company and he is also a director in the company, if he is aggrieved in the capacity of director, that operation is not covered by this chapter. Then change in status to minority is not operation. For example, any change in the shareholding pattern of any member due to amalgamation, reduction of share capital, or any other reason does not amount to operation. Then mere denial of inspection of books of accounts does not amount to operation. I have highlighted the relevant case laws alongside of important points. Okay. Coming to the next section, section 245, class action. In class action, we make an application. Who are we? We are the members or the depositors. We make an application to the tribunal that the affairs of the company are not being conducted in a wise manner. So we make an application to the tribunal seeking relief. Here the depositor also gets a right to make an application. How class action is different from the application we made in section 241? See, we make an application under section 245 if these things are going wrong in the company. What are these? These are what? If the company has committed any act which is ultra virus to MOA and AOA, if the company commits any breach of provisions of MOA and AOA, if the company acts on any resolution that has been passed by suppressing of material fact, if the company does any act which is contrary to the company's act or any other law, or if the company takes any action which is contrary to any resolutions, or if the like these are what these are the reasons why we make an application under section 245. We know these things are not going right in the company, but when we do not know what all the things are not going right, we know that there is something wrong going with the company, but we cannot pinpoint what exactly is that. So we make an application under section 241, and we make an application under section 245 when we know the exact root cause of what the company is not doing right with the members or the depositors. Further, one more difference is under section 241 only the members can make an application, but under section 245 people who are holding public deposits can also make an application for seeking relief. So who all members or depositors can make an application? The members or depositors who can make an application on the ground that management or conduct of the company are being conducted in a manner which is prejudicial to the interest of company members or the depositors. Who can apply eligibility under section 245? So members having a share cap for the company having a share capital, and for company not having a share capital, and the class of depositors. For the company having a share capital, 1/5 of the total numbers of members can apply. For the company having a share not having a share capital, 1/5 the total number of members. For the company having a share capital and which is an unlisted company, 5% of the total number of members, 100 members or members holding 5% of the issued share capital, whichever is lower. And in case of company having a share capital which is a listed company, so 5% of total number of members, 100 members or members holding more than equal to 2% of the issued share capital, whichever is lower, they can make an application to the tribunal. And in case of depositors, 5% of the total number of depositors, 100 depositors or 5% of the outstanding depositors, whichever is lower, they can make an application seeking relief. So what are the remedies which are available under section 245? The tribunal may pass any of the following order. First, to restrain the company from doing these acts, to restrain the company from committing an act which is ultra vires the MOA and AOA, restrain the company from breaching of any provisions of MOA, AOA, restrain the company from acting on any resolution which was passed by suppression of material facts. I restrain the company from doing any act which is contrary to company law or any other law, or restrain the company from taking any actions contrary to any resolution. Then the tribunal may declare a resolution altering MOE and AOA as void which was passed by suppression of material facts, and the tribunal may provide the company to claim damages against the company. The tribunal may provide the right to members or depositors to claim damages against the company, the directors, the auditors who have given a true and fair view, who have provided a true and fair view on the affairs of the company, and the experts whose consent was obtained at the time of issue of auditor's report. When the application is admitted by the tribunal, a public notice shall be served to all the members and depositors, and two class application of the same cause is not allowed, and cost of expenses should be provided either by the company or the person responsible for doing such acts. Then, if any any person has came up with any fictitious application, any application for time pass which was not true, such an application shall be rejected by the tribunal, and a penalty of up to rupees 1 lakh could be imposed against such person. Then section 245 does not apply to banking company, because banking companies are generally governed by the Banking Regulation Act only. Okay, then our last section 246, it says application of certain provisions to the proceedings of under section 241 or 245. It says certain provisions of winding up of company applies here. We will cover this in the winding up chapter. Okay, so this is all about this chapter. This is a very small chapter. You should not leave this chapter because you can easily get 6 marks. Okay, so I hope you liked this video. If you did so, please hit the like button and please subscribe to my channel for further videos. Thank you.